Good afternoon, everyone, and welcome back to the OSHA 3030 with Manesh, Rath. We have a great topic today, and this, for those of you just joining the community, the OSHA 3030 community for the first time, this is a program that we do about every 30 days, and we try and cover a new developing issue in OSHA law, in the field of occupational safety and health law, in about 30 minutes. I'm joined today by my colleague, Javane Nakumaram. Javane, welcome, and thank you very much for joining us.
Thanks for having me, Manesh. I think this is a really great topic for today.
I think it's a great topic. As I mentioned, I'm Manesh Rath. We are here at Keller and Heckman in Washington, D.C. And for those of you who have participated in other programs but want to see if they've missed any, all of our episodes are libraried on our website, khlaw.com/OSHA3030. And you can catch, when you go to that website, you can catch all of our past episodes of the OSHA 3030 that span over 7 years. Both the slide deck and the audio are linked together and play in a self-executed file. You should also know that we rebroadcast this program as a podcast, and it is available on your favorite podcast streaming app like Apple iTunes or the Apple Podcast app. We're even on Spotify. We're also on SoundCloud. And so if you just subscribe as a podcast, it'll automatically get downloaded, the sound portion, and it's a good way to catch our program on the go. So with that said, Javane, why don't we get started talking about what we're going to talk about. The case that we've selected today is a D.C. Circuit opinion. That is the U.S. Court of Appeals for the Circuit of the District of Columbia, one of the highest courts in the land, and by being a Circuit Court of Appeals court. And the case is Manuas Incorporated versus the Secretary of Labor. Great case.
I agree. So what we're going to do is we'll start with just some of the background of the case, and then we'll review one of the most cited decisions that Manuas relied on throughout this case, which was the Sasser Electric Manufacturing Company decision. And then we'll review some of the key concepts of the employer's reliance on the contractor safety expertise. And then we'll get to the D.C. Circuit decision. And then finally, as always, what employers should do.
Yeah, and there's quite a bit. I think under that last category, these practical takeaway items that you can walk out of this program with to improve your safety and health program as you go forward in light of the Manuas decision. I should point out that we are going to refer to Manuas with the possessive apostrophe S at the end. This is a grocery store, basically. This is a retail store, and like a lot of grocery stores, Albertsons, for example, there's an apostrophe S at the end,
right.
as is the case for Manuas. So our case, for those of you who haven't heard of this particular grocery store or go shopping there frequently on Saturday mornings, there's a reason for that. Our case is set in Pago Pago on the American Samoa Islands, and this is the second OSHA 3030 in a row that we find ourselves in the South Pacific, which is extremely unusual, but these are U.S. protectorates and therefore within the jurisdiction of OSHA. So here's what happened. Manuas, the retail store, wanted to engage in some construction at one of its retail stores, and it hired a contractor to engage in the crane operation work for removing steel beams from a shipping container and placing them for staging for construction. So the crane operator it selected was APECS, or Apex, I suppose, and they engaged this crane operator to unload or offload these steel beams and stage them on site for the next step. And some of the new employees were there for the offloading process. They were assisting in various tasks with the project, but Apex was the one actually operating the crane and doing the offloading task. Apex engages in the task. Its crane operator is operating the crane. It didn't take the preliminary safety measure as required under the crane's standard of measuring the distance from the crane to any overhead power lines. And unfortunately, while unloading steel beams, the crane boom touched a live power line, and the result was catastrophic. 3 of Manua's employees were electrocuted and killed. Several others were hospitalized.
Right, and I think it's also worth noting that not only did Apex not, measure the distance from the power line to the crane, but they also they failed to provide any safety information or training to any of Manua's employees who were helping out with the project. Apex, when they were negotiating their agreement with Manua, they asked that a crew of Manua employees help out with some of the attaching the beams to the crane, and so they failed to help those employees understand the safety precautions, and then they also failed to do any of their own evaluations, and it wasn't part of the agreement with Manua's to begin with. So there are several steps that were missed in this process before the incident occurred.
Yeah, what they essentially did, Javane, was they just engaged Apex and had them do it. They didn't go through any instructions to Apex. They didn't ask any questions of Apex as to how the work was going to be done. And they just expected Apex to come do the job. And in addition, they had never engaged Apex to do this work before, which is understandable. I mean, this is not, Manua's is a retailer. It's not in the construction space. But those were omissions that you would not see, hopefully, from experienced participants in the construction industry, the way you saw that with Manua's engaging in its own construction. So OSHA comes in, they conduct an inspection, and they issue citations for several citation items under the Cranes and Derricks standard. Manua's files a notice of contest, and they ask to be heard before an administrative law judge. And this goes through to the administrative law judge for decision. Manua's argument was essentially, look, Apex was engaged to handle the crane. They handled the crane. They handled the crane in an unsafe manner. They didn't look out for overhead power lines, and they made contact with an overhead power line. That failure to clear the site of overhead power lines or to maintain a safe distance was the violation of the requirement under the crane standard. And so that failure properly belongs to Apex. We're a grocery retailer. We engage them to handle the crane operations. They should know how to do it safely. And that seems to me, Manua argued, to be something that we shouldn't be held liable for. The administrative law judge, whom we know, argued before in the past, is an excellent judge. She essentially said, well, I've looked at both arguments, and it does appear that Manua's, when you look at the facts of their involvement in that particular task, did share some responsibility for compliance with the standard. And specifically, they ought to have known to comply with the standard with respect to clearance away from overhead power lines. Manua's challenged this administrative law judge decision to the Review Commission. And the Review Commission sat on this and issued a decision last summer, I think. No, it would have been earlier than that. It would have been early last year at the earliest. So I think it would have been late 2018. And the Review Commission agreed with the administrative law judge, and Manua's petitioned then to move to the D.C. Circuit Court. So to be clear, the decision from the Review Commission was issued, and that upheld the administrative law judge decision, and then the folks at Manua's challenged this to the D.C. Circuit Court. So, and that was July of 2018 that the Review Commission issued its decision, and then the D.C. Circuit Court issued its opinion, I think last month, a couple of weeks ago, January 28th. And now we are here at the OSHA 3030 to review the D.C. Circuit Court opinion, which was issued 2 weeks ago.
So I think to before we get into the D.C. Circuit decision, it's important to point out the precedent that Manua's wanted to rely on in order to argue that it was not Manua's responsibility for the OSHA violations that occurred, but it was in fact the contractor's responsibility. So the precedent that Manua's relies on is called the Sasser Electric Manufacturing Company case, which is a review commission decision. And so this decision, they had a lot of similar facts to the Manua decision, but I think the main takeaway is that this decision provides a narrow exception to the rule that an employer is responsible for OSHA violations. There is a narrow exception that an employer is justified in relying on an expert or a specialist to protect against hazards related to the specialist's expertise, so long as this reliance is reasonable and the employer has no reason to foresee that any of the work will be performed unsafely. So in this Sasser decision, the employer had hired a crane operator to lift a generator off the ground and place it on a trailer, and Sasser hired the crane operator to do this kind of work in the past, like roughly 6 separate times. So they were familiar with their history and they had no issues in the past. And in this case, there were overhead power lines on the work site, and Sasser warned the crane operator about them. But when the crane operator was moving the generator onto the trailer, it unfortunately touched a live power line, and this caused the death of a Sasser employee.
In other words, the facts in Sasser were remarkably
Very similar.
Right.
And so Sasser was cited for violating an OSHA standard that prohibits bringing a crane within 10 feet of a live power line. But Sasser argued that they were not responsible because they reasonably relied on the crane operator's expertise. And so this case was taken before the Review Commission, and the Review Commission decided that Sasser's reliance on the crane operator was in fact reasonable because Sasser had no expertise in operating cranes, and only the crane operator was in direct control of the crane. And then finally, the entire job only took a few minutes, so the violation was very sudden. It wasn't a long, ongoing violation. So that's essentially the criteria that was applied to, what is a reasonable reliance on a contractor. And what we call the Sasser exception, it was contrasted in another case, which is called Fabi Construction Company.
Yeah, it's really an exception to the exception, if you will, or an example of when the Sasser exception would not apply.
Right. So in this case, and this was a D.C. Circuit case, it explained that an employer's reliance on a specialist is unreasonable when the employer has a reason to foresee danger to its employees. And the court looked at the employer's expertise, its amount of control over the work site, and the amount of the duration of the violation as factors to look at in figuring out, is this reasonable or unreasonable reliance. So in the Fabi case, the employer construction company, they hired a contractor to do shop drawings to provide specific building directions to its workers, and these drawings contained errors. So unfortunately, when employees poured concrete into a hotel parking garage in accordance with these drawings, the garage collapsed and killed 4 Fabi employees.
This was the Tropicana Casino in Atlantic City.
Right, it was very, very unfortunate. And so Fabi was cited for several OSHA violations, but they argued they were not responsible for the OSHA violations because they relied on the contractor who did the shop drawings. But the D.C. Circuit here disagreed that that Fabi's reliance was reasonable. Fabi, unlike in the Sasser case, Fabi's they had expertise in shop drawings, and they in fact reviewed the contractor's shop drawings and revised them. And they interpreted the shop drawings, and the employees there were executing the plans directed by the drawings, so they were much more involved. And also, Fabi was aware of hazards that were presented by these drawings for weeks, and they had time to recognize and abate the hazards. And so therefore, due to all those factors, their reliance on the contractor was unreasonable. So it's different than Sasser.
There's a lot of things different with it. When you see an error in a shop drawing, of course Fabi implements the shop drawings, and so there's no doubt that they know how to read the shop drawing. Whereas, as you say, and that shop drawing they had for a long period of time, a couple of weeks, whereas as you say, when you talk about crane operating, like in Sasser, or here in the Manua's case, you're looking at something that's happening in real time. The violation occurs, and within a second or seconds, the hazard emerges. And that's precisely why you need somebody to operate the crane in an expert manner, expert as to safe operation, not just operation. So the D.C. Circuit looks at all of the arguments from both sides as to whether or not the Review Commission applied the Sasser exception appropriately. And essentially, it comes down to this. Whether or not the Review Commission issued its decision in an arbitrary manner is fundamentally based on whether or not Manua's was reasonable in relying on its contractor, Apex, to perform the work safely. When the D.C. Circuit looked at the facts that were similar to the Sasser opinion and dissimilar to the Sasser opinion, it essentially concluded that the Review Commission got it right, that Manua's was not reasonable in essentially handing off the entirety of the responsibility for safety to Apex without regards to what steps Manua's could have taken to improve safety during the crane operation for that offloading task. It's true that in Manua's and in Sasser, the crane operator was hired out to a contractor. And it's also true that the understanding between Manua's and its crane operator was the same essentially as with Sasser and its crane operator, that in both cases the understanding didn't specifically mention responsibility for compliance with safety standards. Neither Sasser nor Manua's asked their respective crane operators, what safety measures are you going to take? There is one difference, although it's also true, by the way, that Sasser's and Manua's both had their own employees at the task site when the task was being performed. The level of involvement between the two was slightly different. Sasser's employees were observing, and Manua's employees were actually participating. As you say, Javane, they were performing the rigging prior to the hoisting, and they were calling out to the crane operator, which, by the way, the folks at Apex testified meant that it was Manua's employees that were giving signals to the crane operator. Manua argued, no, that wasn't signaling. That was just our employees happened to be talking to the crane operator. There's a level of difference based on who's controlling the task. And Manua's argued that it was the folks at Apex, the crane operator. Nevertheless, there is that dispute, which didn't exist in Sasser. So the D.C. Circuit concluded that there were some relevant distinctions. First of all, that higher degree of involvement by Manua's employees. They were actually involved in work, the rigging, being on site, and calling out to the crane operator. And the idea that Manua's had never used Apex and thus would have had a higher degree of responsibility for vetting whether Apex was capable of doing this work safely or whether it would engage in any preliminary safety practices like site inspection. And just generally that Manua's had no agreement where Apex was specifically assigned safety responsibilities. Finally, Manua's got to decide where the steel beams would be placed and where the shipping containers were to be deposited for offloading and then subsequent placing of the beams. And so, since Apex was using locations that Manua's had cited and selected, it would have been, the circuit court argued, it would have been the responsibility of Manua to cite the shipping containers and the placement of the steel beams in a safe location, away from overhead beams. So, as a result of all of that, the circuit court concluded that it wasn't reasonable for Manua's to simply rely on Apex to come in and do the job safely. They should have taken a little bit more of a hand on the subject of safety and health and how to perform that task safely. Okay, well that's Manua's. In light of the case, let's talk about what you, as a part of the OSHA 3030 community, can take away from the Manesh case in order to improve the safety and health operations at your work site?
Right. I think there are some important lessons to take away from this case. So first, we recommend that you use a job bid process to evaluate a contractor's ability to perform the job safely and the safety measures that will be used. I think one of the big issues in the Manua case was when they were looking for a contractor to hire, they didn't even ask about what safety measures that Apex was going to use, and they didn't know their history, and they hadn't worked with them before to come in order for them to form a reasonable reliance that they would be performing the job safely. So doing that upfront research and having that information ahead of time would be really helpful.
Well, Jevin, I think to be clear, much more importantly, it's important to bid out the process. Manu is so selected from anything I could tell from the opinions, contacting Apex and then just having them do the job. And what an employer can do in order to make use of its reliance on experts as an affirmative defense is to start with a bid process. And one of the questions that has to be asked in the bid process is, what is your experience with this kind of task? What safety steps do you propose taking if you get this work? And review all bids and in part their answers to this question and see how they propose to do the job in a manner that's safe and what safety measures they specifically propose taking. Even if you select a different contractor, you will learn what safety measures the community of bidders is severally proposing, and you may cross-pollinate some of those ideas to other other subcontractors to try and vet whether or not the selected or non-selected vendors' methodologies are the best practice that can be implemented for your particular task. So that job bid process is the starting point where you got to start thinking about safety. It's too late when your subcontractor arrives on site. Then when you've reviewed all of these bids and you select a bidder, then the engagement in contract should incorporate the information that's exchanged during the bid process. In other words, if a bidder said that he would perform a job using safety measures A, B, and C, those safety measures A, B, and C should be incorporated in the contract. Now they should be contractually bound to put up what they promised that they would do in a manner that they said they would do it. So those are twins, the bid process and then confirming it, nailing it down in the contract are twin steps, and the safety steps for the task should be incorporated in both parts of this dual relationship between bids and contracts.
Right. And I think going along with that as well is reviewing the contractor safety history prior to selection and requiring that the contractor only provide workers with the safety training that's relevant for the site.
Well, that first one can be done in the bid step. When you go through the bid process, you should have bidders provide their safety history. This should be in the form of OSHA citations as well as workers' comp records. Then, when you select a contractor, you should require by contract that the only workers that are sent to your job site are ones that have received safety training for how to do this task safely. Again, the twin relationship between bidding and contracting manifests itself on the question of safety history, the use of workers, training of workers, etc. And then it's not enough after you've selected the bidder and he's promised that he will do the job safely and how he will do the job safely. Then I think you have some responsibility as the person who controls the site. Remember, the workplace, the multi-employer work site doctrine still reserves some exposure or liability or responsibility to the person who can control the hazards of the work site itself. So if there are hazards that are native to the work site, and overhead power lines would be an example, then it's the responsibility of the job owner to convey or communicate those hazards to the contractor and say, hey, listen, and when you come on our site, you should know about a series of features. Here's where the gas pipes are. Here's where the overhead lines are. There's pits, trenches, etc. This is what the soil condition looks like. Or we don't know anything about the soil condition. We require you to perform soil testing. Those are the kinds of things that are natural to the job site that need to be communicated. Confined spaces is another one. And that duty, I don't know how you can contract that one away. If you're aware of job hazards that are part and parcel of the site, then that's your duty to communicate those to your vendor.
I think that's right, and that's what Sasser did. In that case, the employer notified the crane operator that there were overhead power lines.
Right, and Manesh didn't.
That's right. I think also it's important to clearly define yours, the employer's versus the contract worker's responsibilities if you're working on a project together. As we saw in the Manua case, we had both Apex and Manua's employees doing this whole project together, and yet it was unclear who's responsible for training and for the safety component of that. So it's important to figure out in advance what are the contractor's employees going to do versus your own employees if they're required to help.
Well, the contractor doesn't have control over a lot of elements of the property. So, for example, cleanup in between shifts is going to be the responsibility of the job owner. The other, in this particular example, we had overhead power lines. These things should be spelled out in the contract. Who is responsible for which safety-related tasks, and every single element of it should be spelled out the best that you can anticipate those kinds of responsibilities coming up. So for the example of the overhead power lines, Manua should have reserved onto itself, an employer should reserve onto itself the duty to de-energize those power lines during the time in which the overhead crane work is being done by maybe contacting the local utility and asking that it be de-energized. Who's going to provide the safety monitor to constantly monitor that the job is being done safely? Well, if it's a technical task that requires specific expertise, crane operating may be one of them, then you will want to allocate by contract the duty to provide constant job safety monitoring, that the contractor must provide that service. You may require that the employees, as we mentioned earlier, the employees who come on site, you may require that they all receive safety training and identify the specific safety topics that they need to be trained on before coming on board, not just safe crane operation, but maybe you need to have them trained on personal protective equipment. You may need to have them trained on where trenches are or what to do about them. There's a whole bunch of safety topics that each employer may want his subcontractors to be trained on depending on the specific hazards of the job site, confined spaces, for example. And then there may be job site hazard awareness training that you may need to conduct yourself for your own employees, and you may require your contractors to send their employees to attend this training as well. Now, I will note, by the way, I'm well aware that OSHA or the Department of Labor have exchanged memoranda suggesting that the training element of a subcontractor's employees may create an opening for OSHA to allege that there's shared liability. But when it comes to safety and health, that may be one fact that you may have to concede in order to make sure that safety is achieved. In other words, if by training all visitors on where the job hazards are, the site hazards are, or what precautions need to be taken when entering the site, such as sound protection, bump pads, etc., hearing conservation protection, I meant, then that may just be the cost of having to make sure that everything is as safe as achievable on that job site, even if there is an acknowledged assumption of risk that OSHA might allege that served as evidence of some kind of co-employment relationship. The last thing I want to say is to be mindful that the idea that you can rely on the expertise of your special subject matter experts, like crane operation, is a defense. It's something that you have to be mindful of, that this is an affirmative defense. And this is noted both by the Review Commission and by the D.C. Circuit. This is an affirmative defense, which means you have to raise the subject ahead of time at the initial exchange of pleadings. And all affirmative defenses have to be noted at the initial exchange of pleadings. That means, and this is becoming a constant theme, Javane, here at the OSHA 3030, the theory of the case has to be well thought out and premised upon a thorough investigation at the earliest stage of taking on a contest against an OSHA citation. And too often I see examples, and I think this is another one, where the theory of the case develops during the course of litigation in preparing for submitting a matter to the administrative law judge for decision. Whereas some of the issues that you're going to raise, like this one, the idea that you should be entitled to rely on experts, is one that should be thoroughly evaluated at the pleading stage, at the very beginning stage, so so that it can be raised as an affirmative defense, or so that you can evaluate the evidence and make a determination if perhaps you don't have such a great affirmative defense after all, based on the evidence. Okay, it looks like I got the last word this time for the OSHA 30, this month's OSHA 3030. For interim developments, you can catch more news on our LinkedIn pages. Javane Nakumaram, I know you have a LinkedIn page. I do as well. Our colleagues, several of them, David Savati, Larry Halpern, John Gustafson, and several others, as well as the Keller and Heckman Workplace Safety and Health LinkedIn page. We also have Twitter news feeds, at Rath Manesh is one of them. This program, the OSHA 3030, is a podcast available on Apple Podcast as well as SoundCloud, Spotify, and perhaps others that are your favorite podcast streaming apps. The next OSHA 3030 will be on March 18th, 2020, always on a Wednesday, always at 1 p.m. Eastern Time. To register or to find more information, you can catch it at khlaw.com/OSHA3030. Remember, when you get an invitation by email for the next OSHA 3030, all we ask in exchange for the information that we provide through this program is that you forward this program on to three additional recipients so that we can continue to increase the awareness of the program, spread the good word, and increase the size of the community by which we may all benefit. In addition to the OSHA 3030, we have sister programs, the TSCA 3030 and REACH 3030, which will be held next on March 11th, as well, the FIFRA 3030. And that brings us around to our conclusion for this month's OSHA 3030. On behalf of all of us at Keller and Heckman, on behalf of my colleague Javane Nakumaram and myself, thank you very much for participating in this month's OSHA 3030, and until next month, stay safe.